It's, I guess I have another image here that I wanted to bring up, particularly this one, because Cooley made a point which I meant to advert to a moment ago, which is that problems have a way of rising up the level of government. Whatever's going on at the local level, if people aren't very happy with it, they'll want to get the state into it. He also made another point that I intended to advert to, which is that the courts, the Supreme Courts particularly, need modesty, and they ought to be trying to explain the law in terms of what he referred to as the common thoughts of men. He wrote the best book on constitutional law in the 19th century, and he was given a PhD at Harvard University in 1886, and he told them, hey guys, stay loose a little bit. Will you remember that the law is intended to express ideas that ordinary folks can understand and read, and you interpret it the way they would interpret. The Supreme Court has lost sight of that impulse to modesty that he advocated, and as I say, Louis Brandeis was also an advocate of that. What can we do about the Supreme Court if we were trying to have constitutional reforms? Are there things that could be done? They could be done mostly. I've got a list here of things that several of us have been advocating, as these are changes in the Supreme Court that we had a little conference on it last year in Washington, and there are a bunch of law professors who think there are a bunch of things that Congress could do to the Supreme Court, and then you wouldn't have to amend the Constitution to fix it at least somewhat. And one of them is simply to declare that we're going to appoint a new member of the Supreme Court every 2 years, and the 9 junior most of those sitting on the court will be normally the people who sit and decide cases. That would, in effect, establish something that looks a lot like an 18-year term, which isn't a very big change, but it is, one of the things we're looking at is a situation in which the Supreme Court justices, Clarence Thomas may well be on the Supreme Court of the United States for 50 years. If he lives out a full life, and that's nuts. It doesn't make any sense to have somebody exercising that much political power 2 or 3 generations away from those who selected him to perform the office. So that would be one reform. Another is to rotate the Chief Justiceship. That was a modest, the only duty that job had for the first 150 years was simply to hold the gavel when they were having hearings. And in the beginning of the 20th century, they started giving, William Howard Taft had these notions of giving the Chief Justice the powers to organize the federal judiciary in diverse ways, and they made him responsible for a whole bunch of different kinds of committee management things. And there's no reason why he should be absolutely invulnerable in making those decisions. There ought to be some accountability, and somebody ought to have to appoint or reappoint that person every now and then. The most appalling thing about the Supreme Court, to my taste, is what they've done with their docket. They just don't bother to decide very many cases anymore. 1930, 40, they were deciding 350 cases a year. And the power that they were granted in 1922 to control their docket, they began to exercise more and more and more frequently and cut the load down to 150, and now it's down to about 75. And I guess in the next generation, they'll get down to 25 or 15, I don't know. They just decide the cases that look like they'd be fun to decide, that'll make a big difference. And they're not really interested in the routine task of enforcing law. They leave all that to the lower courts, and if it's a circuit split, they don't care. Circuit splits are all right, we can just have local regional law. But that is their job, is to try to harmonize what's going on in all the courts, and they don't much do that. So that's another complaint, and one of the suggestions is we could give some circuit judges the responsibility of picking part of their docket and saying, fellas, here are a couple of hundred cases for you to decide every year, and if you've got some others you want to pick, that might be all right too, but at least you have a duty assignment that would make the job a little more modest, a little less fun, and they might be a little less self-indulgent. There is also another feature that's pretty weird, and that is they are totally, I mean, we say they serve for life. That's not really quite correct. The Constitution says they serve as long as they are, their behavior is good. Well, one of the things that's happened is that they tend to overstay their competence. And that used to be dealt with by the Supreme Court justices internally by having them confront a disabled and elderly justice and say, Your Honor, it's time. And that sort of faded out in the 20th century. And they don't do it anymore. And now William Rehnquist, who was certainly competent to be a justice for a good long while, but the last year that he was on the court, he was in the hospital. And somebody should have had responsibility for going to Bill Rehnquist and saying, Your Honor, it's time. And you're not doing the job anymore, and we ought to have somebody else in here to do that. Another issue is televised hearings. The justices don't want to be televised, but it might impose a little more modesty on them if they thought they were out in public doing whatever it is they'd like to do. So those are things that Congress could do to cool the Supreme Court a little bit, and I think they would be positive reforms. The Citizens United case I mentioned with regard to judges, there's another aspect of this, and that is mentioned earlier, the extension of the First Amendment in ways that are unfortunate in my view. And we are confronted in thinking about the state courts particularly with some of those consequences. Well, I brought along an image of your state legislature that is having to struggle with the same bunch of issues that Congress has to deal with, particularly with regard to money that the Supreme Court of the United States has imposed on them. But I really wanted to, well, how can I go back here? What do I do to go back? Well, no matter. Skip it. I had a image here of that wonderful cracked lady justice that is a local novelty, and the point I wanted to make here about the campaign finance thing was that in addition to raising money to be a judge, you also have problems about what it is you can say and what it is you can do in a judicial race. And we had a spectacular example in 2009 of the problems of campaign finance and what you can say in a judicial campaign. This particular Justice Benjamin sits on the West Virginia Supreme Court. And he was the object of a Supreme Court decision, which did, I think, come out by the barest of margins with the right answer. He had a former client. He had a client who bought him a seat on the Supreme Court of West Virginia for $3 million. And he got elected, and then his client's case came up, and he cast the deciding vote in favor of the Massey Coal Company in a big case. And there was argument that he had to subside, that he had to retire, and that it was a denial of due process of law to have a judge who's taking $3 million of campaign funds from one of the litigants. He cast the deciding vote. He refused to recuse himself. So it did go to the Supreme Court of the United States, and the Supreme Court of the United States did hold 5-4 that $3 million was too much, and you have to subside, you have to retire from the bench when you've taken that much money. Justice Kennedy was the marginal vote, and he made it clear that, well, you know, it was a little less, maybe it'd be okay. And he didn't say where the line would be drawn, but it is clear that the Supreme Court has gone all over this First Amendment stuff, creating very serious problems for the integrity of our state courts, and for that matter, the state legislatures as well. So those are my concerns. We, as I say, in North Carolina, we have this system, and it has, I suggest it for your consideration in Michigan. The voter's guide is part of the game, and it's a public document, and the judges get to put in whatever they want in their campaign in the voter's guide, and we distribute that to all the citizens of North Carolina, anybody who wants a copy of it. And it is a fairly clean statement of the qualifications of the candidates for judicial office. So what do you need to spend a couple of $1 million in addition to that, put your name on television and rattle everybody's cage about how this guy ought to be put on the state Supreme Court? I hardly think so. It's in any event, it's a system that is very much in jeopardy as a result of more recent Supreme Court decisions along the lines of Justice Benjamin's case, and corporations can spend an infinite amount of money influencing our. What's happened, I would suggest to you, is in many respects the Supreme Court of the United States has become part of the United States Chamber of Commerce. That anything that business interests feel like they'd kind of like to do is being protected by the Supreme Court of the United States without regard much for any of the competing values. And those are serious problems, and Congress needs to address what's going on in the federal judiciary in ways that will bring them down to earth and make it a more modest enterprise and make it more suitable. And I would hope that through this Article V initiative, we might get Congress simply to avoid the necessity for constitutional amendments to make some laws that would achieve some of the objectives that do need to be pursued. If that doesn't happen, then I guess, do we have to have an Article V Constitution to fix Justice Benjamin and make it clear that we don't want people to be able to buy judicial offices? I would hope not, but it's certainly, there are a bunch of questions like that do need attention, and maybe an Article V initiative will help to get Congress and the court on a little better track, because I do certainly share the view of many people that our government in Washington is broken, and somebody needs to do something about it. So to that extent, I lend my enthusiastic support to the Article V initiative, but sort of with the hope that we don't have to get in the situation that California has gotten itself into by sort of popularizing the process and having a bunch of other folks come in and rewrite a constitution that might be even less provident, less wisely crafted than the one we've got, because there are a lot of conflicting interests there, and it's not an easy task to figure out exactly what ought to be done. So thank you very much.